Welcome to Inside the Director Circle and this episode on dispute resolution and avoiding the legal minefield. I'm Jason Langford-Brown, your host, founder of the Director Circle and practicing business advisor and coaching psychologist. In the last episode, we started this topic by focusing on how to resolve a dispute or even a conflict, but what happens if it escalates into what we would technically call a formal dispute and it gets legal? This episode is all about how we navigate that minefield. And to help us with this, as always, we're delighted to work on one of our knowledge partners from the Director Circle. Today, that's Alex Bishop, Managing Partner and National Head of Dispute Resolution at Shoosmiths, one of the UK's leading and award-winning, and in my experience, most progressive law firms. And to add a practical element, one of our business leaders, all the way from Atlanta, Georgia, Angie Fife, CEO of PDSI, a market-leading property development services firm operating across the US, South America, the Caribbean and beyond. And just very quickly, before we get into the discussion, remember this is just a snapshot of what happens within our business leader community. So if you want to get more involved or get some deeper insights, visit directors-circle.com and click Join the Community button. So Alex, we'd have to start with you on this one, as this is all about legals. I'm kind of just thinking probably the place to start is what do you even do if you get a legal letter or some kind of legal approach around a dispute?
Don't ignore it. I say that flippantly, but again, too many times have clients come to us and thought that, they didn't need to respond to a legal letter or it would just go away ostrich-like because, of course, they don't want to do it. So, no, you have to take it seriously. Certainly have a read through the letter, understand what the ask is, understand what any deadlines might be in that letter. There can be, depending on the nature of disputes, legitimately an incredibly short time scale to respond. Okay. Sometimes there can be an unreasonably short time scale to respond, but we won't know that until we kind of understand the nature of the dispute. And then I would say get legal advice. Get that legal advice as soon as you possibly can and understand where you are. Any decent lawyer shouldn't go running off and spending huge amounts of time and money. They should give you very clear steer on what the cost might be, what you might need to consider. But you need to get that legal advice.
Yeah, it's interesting. It sounds like when you owe money, it's like, talk to the people you owe money to quickly rather than ignore it. Then you're less likely to get in trouble. It's the same kind of advice. And I think for you, Angie, have you in experience seen good or bad examples when you have responded quickly or not in the opposite direction?
Sure. So if we have received, what you were calling a legal notice, if we are put on notice, it's typically for performance and it spells out whatever the dissatisfaction is. So two things that we do. One, we do send a copy to our attorney, and then we pull together everyone who's been working on the team so that we can get all of the pertinent information and form a response. It's not just one person, because one person is never going to know all of the facts. Work on that and then send it to our attorneys to review before we do anything else, because 9 times out of 10, the response is going to be, this is good, but you need to take X, Y, or Z out, or you need to reword this, and you need to think about what you're saying here. But, at the end of the day, it's getting all the facts, taking your time, and really writing out exactly our perspective of what is going on. And sometimes there are extenuating circumstances that have come into play, and people tend to forget those easily. So, that also can be part of our response.
Yeah, and I think what you've just described, Andy, sounds really rigorous to me, and I'm interested if that resonates with Alex from a legal perspective. But I really like the part of that where you bring the team together right at the very beginning, immediately. Alex, from as a lawyer, how does that sound to you?
So again, look, there's jurisdictional aspects to this, and different jurisdictions will have different considerations. So one of the things that as an English lawyer, I would be really mindful of in these circumstances is making sure that I'm not waiving privilege, what's called legal privilege, and equally that I'm not inadvertently creating something that could come back to bite me. Yeah. So when I said earlier about going to get that legal advice, that is all wrapped up within that piece, because if Angie is engaging a lawyer and the lawyer is asking that the team put together their recollection for the lawyer in the UK, that would attract what's called legal privilege. If Angie was doing that with her team before even talking to a lawyer, potentially there is a risk that those documents are then disclosable. And again, there's a massive difference in terms of how disclosure works in the US and the UK. So you have to be careful. There's something called litigation privilege that will often help in these scenarios. And clearly we're talking about the potential for a dispute here. So that might help as well. So there's just those sorts of issues over legal privilege. You can try and make it as secure as it can be, so that, and this is a really, really important point, when you're getting that legal advice, you need to be utterly open, transparent, and honest with your own legal team. There is no point telling those lawyers what you think they want to hear, or being selective in your memory. You need to give them warts and all, the good, the bad, and the ugly, because it will come out eventually, and you don't want it to come out way down the line, hundreds of thousands of pounds worth of legal fees later, and the strategy that might be adopted would be fundamentally different had they known that at the outset.
Sounds like a good pitfall to avoid, Alex. But I just wonder if we ought to just clarify for listeners, legal privilege. I think I picked it myself from what you were talking about, but could you just clarify that point quickly for us?
Really good question. As I say, there are jurisdictional differences. So I'll speak from a sort of English perspective for a moment. So the concept of legal privilege is a sort of public policy piece. It's to enable people to have the freedom to get proper legal advice and to be able to have those open and frank conversations with their lawyer and not have to worry that anything they say could be used against them. So
if you've done that before you've engaged a lawyer, then actually that's what you mean. That actually you'd have to disclose those meetings, those minutes, those documents. Whereas if you've done it with the lawyer, then actually you can keep them private. Interesting.
Correct.
Okay. But there may be some differences in the US.
There are differences in jurisdictions, and there is another limb to legal privilege called litigation privilege, which might be able to help you out if you have done that before, but and it hasn't come through the lawyers.
Interesting.
And it's really important, it bites as well, Jason. And I will just say this because, again, I've seen so many of our clients fall foul of this pitfall. There's an issue, a black hole in the accounts, or there's, there's something in terms of, what the contractual expectation in terms of payments, and the clients will go direct to their accountants or their auditors and ask them to do the exercise. Whatever those accountants and auditors do, if the client has engaged them, very high likelihood that all of that information is disclosable.
Oh, okay. Yeah.
So it's if the lawyers engage the accountants as quasi experts, or once we think that actually it could fall within this litigation privilege argument, there is a very high chance that we can protect those documents from disclosure.
Put it into my simple business leader language, Alex. It's almost like, it sounds like you need to let your lawyer or your attorney be the puppet master rather than you as the business leader be the puppet master of the dispute.
I think yes. I mean, of course, you work in partnership. It's but in terms of those instructions, and equally, apologies to accountants who might be listening in right now. Don't let the accountants be the puppet masters because you could end up in slightly tricky territory.
Yeah, absolutely. So I think that was really useful, and you started to talk about pitfalls. So we probably ought to move to that, because I think in the short time we have, it would be good to try and sort of uncover as many pitfalls as possible that are going to happen in a legal process of dispute. So could you maybe share your sort of top 2 or 3 with us?
Yeah, some really obvious privilege is one that I've talked about already. Again, let's go back to that initial letter as well. There may be some aspects of that initial letter that could cause you all sorts of challenges. So again, in this country, we have really tightened up on things like timescales. So if you just ignore something, or even if a dispute has sort of started, there is a set period in which you must file your defence or file certain documents with the courts. And the courts in this country are basically enforcing those timescales really harshly. If you're going to miss them, you need to ask the court for an extension of time before that deadline expires, not after it. or your claim could be struck out, your defence could be struck out, judgment could be entered against you. So, timescales are sacrosanct once it hits a kind of court process. And similarly, I mentioned if the other side have asked for a response, reply within 28 days or what have you, and you just ignore it, they can then issue proceedings against you potentially. And this issue may never have got to that stage, but because proceedings are issued, you then have to pay costs and things of that nature that would follow in this country. And then there are other things, there are provisions within the English civil procedure that are really attractive as a claimant. There's something called Part 36, which I won't go into the detail here, but if your letter has Part 36 on it and it's an offer to accept a sum which might be lower than the total value of the claim, if you don't accept it, there can be really serious consequences for a defendant in those circumstances. Interest. At 10% above base, it could be interest on the costs at 10% above base, and it could be a higher proportion of those costs afterwards. So again, you need to know what you need to look out for, and that's the kind of thing that could be missed.
And I think it's interesting, things like that make me think that business leaders are not going to know all that stuff. But I think probably the point there is if you see things you don't understand, it's probably just to find out what it means before you just dismiss it because you don't understand it and think it's not important.
Jason, that's absolutely right. It's a great point, because this is the other legal pitfall that I was going to mention to you. The other thing that we see time and again, and this is sometimes from really sophisticated clients, it's absolutely the case, is clients thinking that if they say either in a conversation or in a letter that something is without prejudice, then that's a kind of get out of jail card. That letter can never be disclosed to the court, and they can't talk about that in court, and it's without prejudice. Well, that's not true.
So what does it mean? What does without prejudice mean?
So without prejudice is in circumstances where someone makes a genuine offer to settle a dispute or a concession in some way, then in those circumstances, that offer, that concession can then not be brought in front of a judge as kind of evidence that they're liable in some way. And again, it's that public policy piece of trying to encourage parties to settle their disputes without having to resort to the courts and use their time and resources. So it's to incentivize people. But I've seen letters come in that have got all sorts of assertions and positions and this, that, and the other. But there's no concession in there or offer to settle in there. So it's not without prejudice. Just because someone has put in bold and capitals at the top of a letter, it's without prejudice, doesn't make it so.
Doesn't mean nothing I say cannot be used against me. Yeah. so it's in the context of offers and concessions. That's interesting. So you talk, and I think that what you just said there, because I wanted to bring Angie into this conversation as well about settling. I think some people think once it gets legal, you almost has to follow a process. But I think you and I would know that there still is the opportunity to settle outside of the legal process, and I suppose we're then into the world of mediation. I wonder if people, when it gets legal, are sort of fearful that it's almost like a sign of weakness now they're in a formal dispute. Angie, do you have a view on that? Whether offering to mediate, even though it's gone legal, is a sign of weakness, or?
Oh my gosh, no, that is not a sign of weakness. At the end of the day, what you both want to do is walk away with the same amount of hurt and pain, because it's painful for both parties. So, if you're getting to that point, things have gone sideways. The goal is to never get there in the first place. So approaching with the objective of winning is only going to enable your attorney to buy another lake house, because it's going to cost a lot of money. I'm so sorry to say that, but it's so true. Think about it in terms of your reputation. I mean, you might have gone sideways, but this still could be a client going forward. And so settling could be the best outcome for everyone involved. And I think if you take that long-term perspective, then people understand this is why we're doing it, or it's so much easier. Now, if it's completely, unfounded, that's a whole different ballgame. But hopefully if it's an unfounded claim, you don't get to that place.
And I think you're right. In the last podcast, and you were talking about, showing some empathy and understanding all the component parts from both sides. There aren't many disputes that there aren't issues on both sides, are they? It's always, I would say there's three stories. There's one person's story, the second person's story, and the truth somewhere in the middle. So I think you're right. So, Angie, I don't know, have you actually used formal mediation, or is it something you do consciously as an organisation, or is it something that's a bit organic? How does it work? How does mediation work for you?
Well, fortunately, we've not had to get to that point legally. We, as a practice, have had to put some of our vendors on notice before, and it's a notice of lack of performance, but the goal is always to initiate some kind of performance improvement plan. So, we're not doing it out of spite or anything else. There's got to be a goal to motivate for all of us to get to a finish line, because ultimately changing a team midway through is going to cost all of us time and money. And we really want to avoid that.
Yeah. I love that language of performance improvement, because it's almost like, I'm not just slapping you with something here. I'm actually saying that we need to go into a process to get this right. So you're almost facilitating a mediation in some way there with the language almost. Right.
I don't know many people who want to put someone on notice, sue somebody just because they have nothing better to do with their time. There's always something in the background. So, it seems to me that both parties, if you have reasonable parties, are willing to get to that place where you are mediating and coming to a solution together, and then can work together again down the road.
Yeah, absolutely. Yeah, which would be the perfect outcome. Absolutely. So provocatively, Alex, as a lawyer, do you dissuade people from mediation?
No. In fact, quite the contrary. I mean, look, Angie's absolutely right. There are some instances where the court process is the only way. Issues of fraud, or if you have to freeze someone's assets quickly, or you need to set a precedent. Of course. But, and I genuinely mean this, absent those cases, I see it almost as a failure if I have to go down the court route. Certainly if I end up in a trial environment. Our job is to try and keep our clients away from that process and sort it out. So, again, the Americans are ahead of us, but, we're catching up rapidly here in the UK in terms of our approach to mediation. We're getting very close now here in certainly in England, to the courts even insisting that the parties mediate. And there's a consultation just now actually about the smaller value claims that the courts are going to diarise a court-appointed mediator for those claims. So, I think we need to get far more familiar with the concept of mediation. I do still hear some clients who do think it's a sign of weakness. I'm completely with Angie on this. I think mediation provides a great opportunity for you to continue your relationship. And you can be far more creative in a mediation environment in looking at solutions than you can through a kind of court process that's more of a sort of zero-sum game. So no, I'm fully supportive of mediation. And actually, it's also important to remember that's not the only form of dispute resolution. Alongside the court process, there are all manner of ways that disputes can be resolved. Arbitration is a sort of codified form that's very familiar with a lot of parties, particularly relevant with cross-border and international disputes. Well-trodden path now. You can have adjudication in there. Some really creative dispute escalation provisions that I have seen have included things like executive mini trials, where the CEO of one company, the CEO of another company, and maybe one or two others will effectively hear the dispute. The parties can agree anything they like in terms of potential ways of resolving their disputes. And I would say to most of my clients, there is always something unexpected in the litigation process. Okay. Almost always something unexpected. You've got the risk in terms of, has the judge had a bad day? Are they going to take umbrage with one of our witnesses? That whatever, that could always happen. Your witness could say something in the witness stand that no one was expecting, that you can't control. The other side, likewise, almost always there is some drama when you're in the court process. So do you want to take that risk? The mediation process, you're in complete control.
Yeah.
Go down the court process if you want to, but you are in control of whether or not you're going to agree to resolve things.
Yeah, so it sounds like get the ego and emotion out of the way, and then get into that settlement
100%
state of mind and mediate. So I think just to finish that piece, Alex, for me, mediation is a skill, like many things, and so for some that may be a scary thought. Any advice on how to either acquire those skills or to find the people that could help them when they get to that stage?
There are so many organisations now that offer this mediation service, and some fantastic accredited mediators out there that we've used who are incredibly effective and efficient at trying to get the parties in the right place. But you can have training courses. Your lawyers can help you, train you in what a mock mediation might look like, so you know what to expect on the day. I think going in with the right mindset is a huge part of that. But the mediation process, I think, is fascinating because there's a whole psychology. We can sometimes get frustrated as lawyers that nobody actually starts talking to each other until about sort of 6-7 o'clock in the evening. But there's a reason for that. There's a reason for that, and that's the psychology of the mediation process. That people effectively have their mini day in court in the early day part of the day, where they get to air their grievance and and what have you, and they get that off their chest and can move on from that. And then they get to forced by a facilitated mediator to consider the other side's position, and a third party who's not paid a hired gun. So there's a lot of psychology at that, and even the hunger or the tiredness or what have you, it helps focus the mind. So the process of mediation is a fascinating psychological exercise.
No, and it is. And, I do conflict resolution myself, and you've just kind of made me realize that I think if I could give everybody one tip is, be prepared just to let everyone just have a voice and be heard and not be interrupted. If you can just go through that process, whether it takes an hour a day or even longer before you can try and solve the problem. I think as human beings, we just want to solve the problem, don't we? But until you get all that stuff out, then the problem's not going away. So I think that would probably be my practical piece of advice to everyone listening. Listen, guys, thank you as always for your words. Or maybe just wrap up with maybe just top tip for dispute resolution if you've got to a situation where it's getting a bit legal. Maybe start with you, Angie, and then I'll ask Alex to wrap us up.
Oh, well, top tip for dispute resolution. Obviously, make your attorney your best friend, and go back to the facts. It's just the facts, the contract, and your attorney. Those are the rules of engagement. And if we all know them, there's a better outcome.
Yeah, and I think that goes perfectly back to the first podcast on this series, which, get it right from the start. Yeah, absolutely. Thank you, Angie. Alex?
Yeah, absolutely. It's trying to bring that objectivity into play, which is helped enormously when you focus on the facts. And not opinion and not emotion. And so for me, I guess the follow on from that is that evidential piece. Think about that throughout. Think about the evidence. You can prepare your attorneys enormously by helping them, producing bundles of relevant documents, doing a dramatist, a sort of, a who's who, what their role was, what their names are, etc., and the timelines. All of those things can help enormously. Don't inadvertently start creating documents that are not going to be helpful. Equally, don't start deleting documents, because, again, the courts will just draw an adverse inference if that starts to happen or is seen to happen. So document hold as soon as you've got a sniff of a dispute. So that think about the evidence and that helps you get to the facts.
Great. Thanks, Alex. Thank you both again. In the next episode, we're going to a slight change of subject. We're going to be talking about all things change. I'm going to be joined by Chris Mason, Dr. Chris Mason, who has the only statistically proven change success model in the world. So that's going to be a really fascinating couple of podcasts coming up in the next few weeks. But in the meantime, if you want more on this subject, reach out to Alex and our team at Shoosmiths. I'm sure they'll be delighted to talk to you about all things dispute resolution, or contact us at directors-circle.com. In the meantime, thank you for listening to Inside the Directors Circle.